A New York jury will not hear the profanity-packed emails of original The Walking Dead showrunner Frank Darabont in the trial for the $300 million profits participation battle from the Shawshank Redemption director and CAA against AMC, at least for now. The court is not swayed by defendants' argument that, absent Mr. Darabont's emails, jurors could speculate as to why Mr. Darabont got fired and infer that AMC fired Mr. Darabont to limit his compensation, wrote NY Supreme Court Justice Joel Cohen in an order Tuesday. However, if plaintiffs were to expressly put at issue AMC's motive for terminating Mr. Darabont, for example by alleging that AMC terminated Mr. Darabont as part of a scheme to deprive him of additional compensation, then the door may be open to such evidence, he added. That determination will be made at trial. Seeking to gain an edge, to put it politely, back in 2017, AMC crapped all over Darabont with a salacious document dump that hauled some very dirty digital laundry out in public. The respective emails showed Darabont blowing his stack as he blasted crew and creatives on the series with the likes of "They better wake the F***ck up and pay attention. Or I will start killing people and throwing bodies out the door." Not a good look, everyone can agree. Especially, if you are trying to convince a jury that you are the good guy and AMC are the baddies, if you know what I mean. Additionally, among a series of orders in motion that hit the NY Supreme Court docket today, some other incendiary-ish evidence was booted from the splenetic 7-year-old legal battle. Much to AMC's relief, Darabont and his superagency will not be able to use a fair market value approach. Specifically, today's new orders prevents the plaintiffs from pulling in expert witnesses to discuss LBIG ticket NFL deals with other broadcasters and alike into the trial as a form of context. Which means while Darabont and CAA's legal team may want to argue that TWD should have had a license fee of around $30 million an episode if AMC hadn't been allegedly self-dealing, Justice Cohen says the evidence and testimony adduced by the parties on this point must be tethered to AMC's transactions with respect to comparable programming. Also, the proffered evidence of AMC's total revenue is irrelevant and therefore inadmissible, and the evidence as to the total compensation or net worth of AMC executives is inadmissible. Such evidence is irrelevant and unduly prejudicial, decided Justice Cohen in another order, undoubtedly allowing the likes of now Fox Entertainment boss Charlie Collier and Josh Saplin to wipe some sweat from their brows. However, plaintiffs may probe as to financial incentives the executive has in connection with the outcome of this litigation, Cohen continued, hedging some bets. That may include some description of compensation incentives based on AMC revenues.